My Lord, I am the defendant, applicant, appearing for myself in person, and I most respectfully adopt as my argument in support of this very motion on notice the following processes which I personally fired and served on the prosecution.
Show me! Please, get the microphone from him, please.
I said, show me! Show me!
Excuse me, get the microphone from him.
No, leave it, leave it, leave it. I said, leave it. This is a court of law. I'm under trial. I'm under trial, I have to speak. I'm under trial and I have to speak. Listen to me, please. I'm under trial. I'm under trial.
Please use the microphone.
Channels to seek redress. The convicted leader of the proscribed indigenous people of Biafra, IPOB, Nnamdi Kanu, has filed a 22 ground of appeal to quash the November 20, 2025 judgment of the Federal High Court in Abuja, which sentenced him to life imprisonment.
Something shifted inside that courtroom, and the moment it happened, nothing about this case looked the same again. For years, the name Nnamdi Kanu has carried a weight that goes beyond one man, beyond one trial, beyond one country. It has carried the weight of a question that Nigeria has never been willing to answer honestly. A question about power, about who gets to define treason, about whether a government can lock a man away and call it justice while the whole continent watches. And now, on the 24th of April 2026, something moved. Nnamdi Kanu, known to millions as Mazi, has accepted the terms and conditions set by the appeal court. He said yes, he agreed. He is ready to fight this case from the inside, under the rules of a system that many of his supporters believe was never designed to give him a fair outcome. That decision alone has split opinion across the Southeast, across Nigeria, and among the diaspora. Some say it is wisdom. Some say it is strategy. Some say it is surrender. But what nobody is saying is that this moment is small, because it is not. This is the legal battle that could define what Nigeria's federal government means by justice. And today, it entered a new phase. Before we continue, let us know in the comments where you are watching from, and don't forget to like, share, and subscribe to the channel. To understand what accepting these terms actually means, you have to understand where this case has been and who has been pulling the strings behind the scenes. Nnamdi Kanu is the leader of the indigenous people of Biafra, IPOB. He was arrested in June 2021 and is what his lawyers described as an extraordinary rendition from Kenya. He was brought back to Nigeria without any formal extradition process. He was held in DSS custody. He was charged with terrorism, treasonable felony, and a list of offenses that his legal team has consistently argued were either fabricated or stretched far beyond what the law allows. The Federal High Court eventually struck down most of those charges, but the government appealed, and the case moved to a higher level, and Kanu remained in detention, month after month, well past any reasonable legal timeline. That is the backdrop. That is what makes today's development more than just a procedural update, because the question was never really about courtroom rules. The question was always about political will, about who benefits from keeping Nnamdi Kanu locked up, and about whether any court in Nigeria has the courage to rule against what the federal government wants. Now, the appeal court has presented a set of terms that Kanu must agree to before his case proceeds. His lawyers visited him in Sokoto State, where he is being held, and briefed him on what the court expects. What came out of that meeting was confirmation that Kanu has agreed. He said yes to all of it. The terms themselves are not extraordinary. They are standard conditions for any individual appearing before an appellate court, particularly one who has chosen, as Kanu has, to partially represent himself. Fair hearing protection under the Constitution, court control of procedure, full access to trial records, time allowances for oral submissions, strict adherence to appeal rules, maintenance of court discipline, no legal assistance while actively addressing the court, only before or after proceedings. These are the rules of the room. And Kanu, whose conduct in the Federal High Court was at times confrontational and deliberately disruptive, has now said he will follow them. That is significant, not because the rules themselves are unusual, but because the agreement signals something about where this case is heading. Kanu is not walking away. He is not boycotting. He is not refusing to engage. He is stepping into the ring under the court's conditions, and that changes the dynamic completely. But that was only the beginning, because there is something else happening around this case that cannot be separated from what is playing out in the courtroom. And that is the political environment that has surrounded Kanu's detention since day one. Bola Ahmed Tinubu came to power in 2023 with signals that he might handle the Kanu situation differently from his predecessor. There were quiet conversations, there were back-channel discussions, there were moments where it seemed like a political solution, not a legal one, might be on the table. None of it materialized. What happened instead was that the Tinubu administration maintained the same posture that Buhari's government held. Keep Kanu in custody. Let the legal process run. Do not appear to make concessions to IPOB. Do not let the Southeast interpret any release as a political victory that might translate into electoral pressure. For many observers, this looked like calculation over conviction. Tinubu needed the Southeast in 2023. He received significant support from that region. And yet the man whose freedom many in that region were watching closely remained behind bars. The message that sent, whether intended or not, was felt deeply. Critics argued that Tinubu had inherited not just the office but the political logic that came with it. That the federal government's relationship with the Southeast was still built on control first, accommodation second. That Kanu's continued detention was not just a legal matter, it was a statement. For many Africans who have followed this case, it confirmed a pattern they have seen before. A government using its legal machinery to neutralize a voice it cannot defeat in the arena of ideas. And a president who, despite his rhetoric about national unity, found it more politically convenient to leave the status quo intact. Now the appeal court has forced the issue into the open. By engaging Kanu's legal team directly and setting conditions for the case to proceed, the court has created a moment that the federal government cannot easily manage from a distance. If the appeal proceeds and the court rules in Kanu's favor on key charges, the political consequences for Abuja will be immediate. If the court rules against him, the Southeast will see it as confirmation of what many already believe, that this system was never designed to give Nnamdi Kanu a fair outcome. Either way, the Tinubu administration is now sitting in an uncomfortable position. Because the case is no longer dormant, it is no longer something that can be managed quietly while the courts move slowly. It is now active. It is on a timeline, and the whole country is watching. That is what made this week's development so important, not just that Kanu agreed to the terms, but that by agreeing, he forced the next move. The ball is no longer with him. It is with the prosecution, it is with the judges. And ultimately, it is with a federal government that will have to decide whether it wants to win this case legally or whether it finally has the political courage to consider what ending it differently might look like. And this is where the story gets even more layered, because the Tinubu administration is not operating in isolation. It is operating inside a wider political moment across Africa where governments that align too closely with establishment power, with foreign interests, with the old order of control and suppression, are finding that alignment increasingly costly. Across the Sahel, leaders who once bent to external pressure are being replaced by voices that refuse to. Across West Africa, ECOWAS is under strain precisely because ordinary people no longer automatically trust the institutions their governments built. Across the continent, a generation is making a new calculation. And that calculation goes like this. If the system only protects itself, then the system is not justice, it is management. Tinubu, whether he intends it or not, has become a symbol in that calculation. Not just for how he handles Kanu, but for the wider question of whether Nigeria's leadership represents Nigerian people or represents the comfort of those already holding power. That is a heavier burden than any single court case. But the Kanu trial is where that burden is most visible right now. Every week that Kanu stays in detention without a clear, honest legal resolution, that symbol grows heavier. And every week that Tinubu's government offers no political initiative, no executive engagement, no public acknowledgement of what is at stake for the Southeast, the weight settles more firmly around his political identity. That is why what happens in this appeal court matters far beyond the legal arguments. It matters because it is a mirror, and Nigeria's government is being asked to look into it. Now look at the international dimension of this, and understand why it makes everything more complicated for Abuja. Human rights organizations have flagged Kanu's detention repeatedly. Legal observers across Africa and in the diaspora have questioned the fairness of this process from the very beginning. British parliamentarians have raised his case in Westminster. Given that Kanu holds British citizenship, the UK government has been asked, more than once, to account for what steps it has taken to protect one of its own citizens who has been held in detention in a foreign country under conditions that multiple observers have described as politically motivated. Those diplomatic questions have never been answered satisfactorily, and they have not gone away. What that external attention does is narrow the political space for a quiet resolution. It means that whatever the appeal court decides, the world will have an opinion. And that opinion will land on Nigeria's government, on its democratic credentials, on its human rights record, and on Tinubu personally as the man who had the authority to intervene at any point and chose, at every turn, not to. That is not a comfortable place to govern from. And as the case becomes more active, as dates are set and arguments are prepared, that discomfort is only going to grow. Because silence from Abuja no longer reads as restraint, it reads as a decision, and the world is beginning to treat it that way. Meanwhile, there are layers to this story that the courtroom does not capture, and they matter because they speak to the human reality behind the legal headlines. Kanu's wife, Uchechi, has largely disappeared from public view in recent weeks. Her last substantial social media activity was in early March 2026. In it, she mentions navigating her own health challenges while caring for their son, who had emergency surgery at school. Since that post, silence, no updates, no statements, no public appearances. For the millions of people who follow this case, that silence is unsettling. Because when the wife of the man at the center of one of Nigeria's most politically charged trials goes quiet at the very moment his case begins to move, it raises questions. Is she unwell? Is she under pressure? Or is the silence simply the weight of everything that the past several years have placed on one family? Nobody can say for certain, but the silence itself speaks. It speaks to the toll that this prolonged legal battle has taken on the people closest to Kanu. It speaks to the cost of a case that the government chose to make about terrorism when many of Kanu's supporters believe it was always about speech, about advocacy, about the audacity of demanding something different. And that cost is not abstract, it is carried by real people. A woman managing her health alone while her husband sits in a detention facility hundreds of kilometers away. A son who had emergency surgery while his father could not be there. A family split across borders and held together only by determination and the hope that justice eventually means something real. That is the side of this story that political analysis often misses. But it is the side that ordinary Nigerians and ordinary Africans feel most deeply, because most people who follow this case are not legal scholars. They are people who understand what it means to have a family member taken away by a system that does not have to explain itself. They understand that kind of silence. They have lived versions of it. And that shared understanding is part of what makes the Kantu case so politically combustible. It is not just about Biafra. It is not just about IPOB. It is about whether the state has the right to do this to any family, any community, any voice that it decides is inconvenient. There is also the question of what legal options exist beyond the courtroom itself. Many in the Southeast have called on state governors to use executive powers to intervene. The governor of Sokoto State, in whose jurisdiction Kanu is currently held, has pardoned inmates before. He has done it 3 consecutive years running. But the calls for him to extend that action to Kanu reflect a misunderstanding of how Nigerian law works. Kanu's case is a federal matter. It was prosecuted by the federal government in a federal court. That means the jurisdiction for sentencing and pardon rests exclusively with the federal government. A state governor, regardless of how much goodwill he holds toward Kanu, cannot issue a pardon that has any legal force in this case. Only the president of Nigeria has that authority. Only Tinubu can make that call. And that brings everything back to the same point, the same door, the same political calculation that has kept Kanu behind bars for years and shown no sign of changing. But here is what is shifting. The political cost of that calculation is no longer invisible. It used to be manageable. The federal government could point to ongoing legal proceedings and say the matter is before the courts. That framing bought time. It deflected pressure. It allowed Abuja to appear procedurally correct while doing nothing of substance. That framing is becoming harder to sustain because the proceedings are now genuinely active, because the terms have been set, because Kanu has said he is ready, and because the next delay, the next postponement, the next procedural obstruction will be harder to dress up as due process. It will look like what many already believe it is. A government extending a detention it no longer has a clean legal justification to maintain. And the Southeast is not sitting still while this plays out. Governors from that region are navigating an impossible political terrain. On one side, their constituents are watching the Kanu case and drawing conclusions about where their leaders stand. On the other side, the federal government controls the purse strings, the security apparatus, and the political levers that determine how much room any state governor has to operate. That tension is real, and it is producing a kind of political paralysis among Southeastern leaders that their constituents are losing patience with. The days when a governor could stay quiet on Kanu and survive the political fallout are shortening, because the people are no longer willing to accept silence as neutrality. They are reading it as complicity. That pressure will only intensify as the appeal court hearings draw closer. Governors will be asked where they stand. Senators from the Southeast will be asked what they have done. And the answers, or the absence of answers, will shape political alignments in the region for years to come. This is not just about one man's freedom. This is about whether the Southeast political class has the courage to stand with its own people when it matters. And that question, like the legal case itself, is now impossible to postpone. But here is what is also true. The fact that Kanu is now engaging the appeal process, that he has accepted the court's terms, that his lawyers are visibly active, that the court is setting timelines, all of this means that the moment of legal reckoning is getting closer. And when that moment arrives, it will not just be a Nigerian story. It will be a continental one. Because what is happening with Nnamdi Kanu is not unique to Nigeria. Across Africa, governments have used their legal systems to silence voices they find threatening. Across Africa, people who speak about self-determination, about historical injustice, about political autonomy, have been detained, tried, or disappeared. And across Africa, people are watching to see whether any institution has the independence and the courage to push back. The appeal court in Nigeria now holds that question in its hands. Whether it answers it honestly or whether it bends to political gravity will say something important, not just about one man's freedom, but about whether the law in Nigeria is a tool of power or a check on it. More than that, this case is being watched by a generation that no longer accepts the old explanations. A generation that has seen how courts have been used to manage political threats rather than adjudicate them. A generation that has connected the dots between Kanu's detention and the broader pattern of how the Nigerian federal government has handled the Southeast for decades. A generation that is done being patient. That is what gives this moment its weight. Kanu agreeing to the court's terms is not a small procedural step. It is a man saying, "I am ready. I will fight this inside your system. I will follow your rules." And when the ruling comes, the whole world will see whether your system was ever honest. That kind of challenge is impossible to contain quietly, because it does not just put pressure on the judges. It puts pressure on the government. It puts pressure on every Nigerian institution that has looked away from this case while telling the Southeast to trust the process. The process is now running, and the people are watching. For those living in the Southeast, for those in the diaspora who have carried this story across borders, for those who never stopped following what was happening to Kanu regardless of their position on IPOB's methods, this week's development is a signal, not a resolution, not a victory, not a defeat. A signal that the waiting is entering its final chapter. What that chapter looks like will depend on whether Nigeria's courts can do what Nigeria's politics never has. Give a man accused of challenging the state a genuinely fair hearing. Let the facts speak. Let the law decide. Not the presidency, not the DSS, not the calculations of who benefits from keeping the Southeast in a state of permanent political anxiety. The terms have been accepted. The legal battle has entered a new phase. But the deeper battle, the one about what kind of country Nigeria wants to be, about whether a government can hold a man indefinitely while calling it due process, about whether the Southeast's political frustration will ever be addressed honestly rather than managed strategically, that battle is far from over. And for many Africans watching this unfold, the outcome matters beyond Nigeria's borders. Because the question at the heart of this case is one that echoes across the continent. Who decides what counts as treason? Who decides what counts as resistance? Who holds the power to imprison a voice? And who finally has the courage to set it free? That is the question Nigeria's appeal court is now being asked to answer. And Africa is watching to see if the answer will be honest.